Hello, everyone. With apologies for the delay, I am Mohammed Tavakkoli, the inaugural director of the Elahé Omidyar Mir-Djalali Institute of Iranian Studies at the University of Toronto. I welcome you all to the first session of our winter 2024 Rethinking History, Returning to Archives and Documents, a virtual seminar series co-convened with my colleague, Professor Arzu Azad of Oxford University. Rethinking History is a collaborative project of the EOM Institute at the University of Toronto and the Invisible East program and the Faculty of Asian and Middle Eastern Studies at Oxford. I'm grateful to Professor Arzu Azad for this inspiring initiative. I would also like to thank Invisible East program and the Faculty of Asian and Middle Eastern Studies at Oxford for their collaboration. I'm also grateful to Roshan Cultural Heritage Foundation and the Elahé Omidyar Mir-Djalali for their exemplary support of the Institute at the University of Toronto. At the outset, and before introducing our speakers, I would like to express our collective gratitude to Canada's Indigenous people and acknowledge this land on which the University of Toronto operates. For thousands of years, it has been the traditional land of the Huron-Wendat, the Seneca, and more recently, the Mississaugas of Credit River. Today, this meeting place continues to be the home to many Indigenous people from across Turtle Island, and we are grateful to have the opportunity to live, learn, and teach on their ancestral homeland. My colleague, Dr. Arzu Azad, will be introducing our speaker. Dr. Azad.
Thank you very much, Muhammad John, for passing the word to me. It gives me great pleasure to welcome you all. And of course, my thanks also go to all of you for being such loyal attendees, but also to the Elahé Omidyar Mir-Djalali Institute of Iranian Studies at the University of Toronto, and Mohammed Tavakkoli Taghi and his wonderful team in Toronto. I have also a great pleasure to introduce you to our speaker, whose name is Jairan Gahan, who is currently Executive Director of the Canadian Society for Iranian and Persian Studies. I like that it has both Iranian and Persian. Too often those two are confounded. Previously, she was Assistant Professor of History and Islam at the University of Alberta, and she earned her PhD in Religious Studies, concentrating on the many convergences and divergences between Islamic ideas and ideals and those of the modern world with an eye on women's histories. Professor Gahan's talk today is entitled Sex and the Subject of Law in the National Archives of Iran. And without giving too much away, her presentation will center on the constructed archival category of sex-related crimes to raise questions about the processes of the production of archives, in particular legal archives, and what a critical approach to archives can offer scholars. She investigates the legal consciousness of courtrooms as well as that of archives. She talks about processes of creating, assembling, and retrieving historical facts. She also discusses which subjects and experiences legal archives make possible and visible, and which ones they erode. So it falls very squarely within the topic of our series, which is, of course, Rethinking History, Returning to Archives and Documents. Without further ado, Jairan Gahan, please, the floor is yours.
Thank you so much for the introduction, Arzu. what I'm presenting today is not really a finished project. Rather, I present two ongoing research questions that I've been tackling in the past 2-3 years. And they sort of represent things I have been grappling with regarding both law and legal archives. So I'll talk about the first sort of part of this presentation is more about the actual archives, the sort of assembling, the processes of assembling and production of archives. And then the second part focuses more on the actual sort of legal documents and what they could sort of add to our understanding of modern history of Iran. So I want to begin the talk by an archival riddle that emerged in my research project on the history of the red light district of Tehran. It was this riddle that sparked my interest in what goes into the production of legal archives, and also more generally, the potential that legal archives have. In 2016, in search of archives that would give me access to the voices and lived worlds of sex workers in 20th century Iran, which was the topic of my presentation, my PhD dissertation, I turned to the legal archives stored in the National Archives of Iran. To my surprise, most of the cases that were tagged with the keyword prostitution did not actually involve prostitutes. In broadening the scope of the search through different keywords, I came across a sizable number of court documents and a whole carton and included police reports that were labeled with the term sex-related crimes, جرائم جنسی. Curiously, despite being described in the archive catalog as sex-related crimes, some of these cases, at least at the outset, did not seem to contain any sexually charged references or disputes. They were about inheritance, theft, etc. To add to the puzzle, there's no corresponding category of crime called جرائم جنسی with the same title in any version of Iran's penal code. What then constitutes a sex-related crime? Who decides to put a bunch of court cases together and call them sex crimes, basically? So this slippage between the language of the archives and the language of the penal code suggests a gap between the legal consciousness and the grammar of crime for the contemporary archivists and that of the original early 20th century world of the actual court documents. How can today's researchers use these gaps analytically to write a history of sex and sexuality from the margins of legitimacy? To answer, I reviewed roughly 30 court cases. I'll go through maybe 4 or 5 of them today, which featured crimes such as robbery, family and neighborhood disputes, adultery, fornication, rape, prostitution, procuring, pimping, sex with minors, and acts of public indecency. So this talk centers the constructed archival category of sex-related crimes to raise 2 main questions. First, about the process of the production of archives, as I mentioned, and second, I want to explore the opportunities that legal archives present to scholars of modern Iran. Since also they are underexplored yet extremely rich resources in Iranian studies that offer insight into the life world of marginal subjects who exist at the threshold of the legitimate space of citizenship. And I also have to mention that there are books and there are works such as Hadi Enayat's book on the history of codification and legal reform in Iran, but they do not rely on legal archives really. Rather, they engage with meta debates around positive law and legal reform in Iran in the 20th century. Following Michel-Rolph Trouillot, Trouillot's call to attend to the processes of the production of history, to moments of creating, assembling, and retrieving historical facts, I want to investigate the legal consciousness of courtrooms as well as that of the archives. Which subjects and experiences do legal archives make possible and visible, and which ones do they erode? This presentation further argues that legal archives provide rich historical data and facilitate historiography from below, specifically to uncover how lay and ordinary people navigated the law, but also the modern state. And I'll return to this point at the end of this presentation. Okay, let me begin by giving a quick overview of the history of legal archives in Iran. When did the modern National Archive begin to sort of store these sorts of legal documents? Legal archives in their current form did not exist prior to the post-constitutional revolution period and the emergence of the practice of archive keeping in state institutions. Some earlier court proceedings can be found in the daily reports that provincial governors, the walis, submitted to the royal court. And my colleague Farzin Vejdani's new book, forthcoming book, in fact, investigates these documents. However, these proceedings tend to be one-liners with minimal descriptions of the case and the final ruling. So you just, sort of see this person came to the court for this and the judge ruled this, right? So that's all we get, one-liners, two-liners, if we are lucky, a paragraph. But then once you get into the post-constitutional period, you see, I mean, of course, this is concomitant with also legal reform, which I will get into, the processes of legal reform and centralization of law and proceduralization of court cases. So you start to see these documents emerging as a part of the sort of the bureaucracy of the state that is emerging at the same time. So here, for example, I have just included three pages of different court cases. Usually the way they work is that the first page, this one, the first page sort of describes who is the defendant, who is the plaintiff, and sort of details around that. But then you also have access, so the second one here, to actual interrogation sessions. So the J here is Jawab, the S here is Sa'al. So you literally see what the investigator, you have access to the discussion guides and the interview process, interrogation process completely. And then usually on the left, you see something, this is not exactly, but usually this page would be the page where we see the actual ruling. So the judge would share his ruling and also share his logic. And then in between, there are all these different, so if the cases have moved from, let's say, the normal court to the Court of Appeal, those are particularly the ones that we have a lot of records of. So they only, the state only, or the judiciary only kept cases that were escalated to the Court of Appeal. So we usually have the first trial records, and then we also have access to the second trial records. So following the centralization of trial procedures, the separation of legislative, executive, and judicial bodies, and the bureaucratization of the judiciary in the immediate aftermath of the Constitutional Revolution, the Ministry of the Judiciary began to keep its records, particularly the full records of court cases that were disputed in the Court of Appeal. As such, historians have unprecedented access to the space of the courtroom, interrogation sessions, statements of defendants, and the reasoning behind the judge's rulings in the post-constitutional period. The physical documents, however, are not immediately available to researchers. Rather, they are categorized, tagged, and taxonomized by archive catalogers. A historiographer then only has access to historical facts that have already been sorted through particular language and keywords. What is the politics behind these labeling practices, categorizations, and tagging court documents? What does this process conceal, and what does it reveal? Today, the Iranian National Archives has a large digital platform and a search engine through which we can search for catalog documents online. The last time I spoke to one of the catalogers of the center, she mentioned that there are millions of documents that have not yet been sorted and as such are not accessible to the public. The process of digitization and cataloging is slow and painstaking and not as systematic as one would think. Who decides which carton to open, which collection to attend to, and which keywords to apply is a complicated process that requires engaging with the history of cataloging in Iran, as well as digital humanities, theories, and processes, both of which are beyond the scope of this talk. But for my purposes, which is primarily to introduce legal archives, I focus on the keywords, labeling, and descriptors of legal documents through which the search engine works in relation to sex crimes. So the first sort of mode of labeling that I want to talk about is labeling. It's called, I'm calling it in vivo labeling. So in what I refer to as in vivo labeling, the catalog mirrors the terminology of the actual court documents. And maybe it's actually worth showing this one as well. So for example, this would be the first identifier of a whole carton of court cases that I found in the National Archives. So once you open the carton, you get some sorts of information and so the labeling already starts from here, right? Some sort of descriptor, what kind of شکایت دادگاه عدلیه، وزارت کشور, right? But then when you open the cartons, you also see that it's sort of divided into different files, and then each file has its own descriptor. So again, you hear, for example, this one says پرونده های شکایتی در موارد خیانت در امانت، سرقت و فحشا. So someone has decided that to sort of lump together theft, prostitution, and I don't know how to translate خیانت در امانت, right? So these all become one particular file, and then within that file, every single sort of court case that you open would have another descriptor, right? Here, for example, that is actually this is where we start seeing the process of tagging. So this here says وزارت عدلیه Tehran, the place, دعاوی, complaints, محکمه شرع, شرعی, court, زنان, women. So this is sort of how someone has decided, and it's very difficult to know what went into this sort of process, but someone has decided that this particular court case needs to be tagged by these particular descriptors. So in vivo labeling, as I was saying, really sort of here, the catalog mirrors the terminology of the actual court and the legal grammar of the time. For instance, many documents are described with the term unchaste and dishonorable acts, بی‌عفتی و بی‌ناموسی. This term, in fact, matches the title of a category of crime under the first penal code presented in 1916 by Nosratollah to the Third Parliament as the customary penal law, قانون جزای عرفی. Lustfulness, shahwatrani, attempts to persuade, deceive, incite, or encourage women and girls into lustful acts and forced intercourse, sex with minors, prostitution, and other acts against chastity were criminalized under this section of the Penal Code. Although the code was never officially legislated, it's worth noting, due to the annulment of the Third Parliament, it was put into practice until 1925 when another sort of a new penal code came into place. Since the term act of decency belongs to the legal language of the 1910s, such labeling practices take us directly to the legal consciousness of the time, which tells us something about the legal grammar of indecency and its intersection with the everyday lives of citizens. What counted as public indecency in the 1910s? How did defendants narrativize their acts so as to avoid conviction? Who were the targets of this law? For one example, the specific keyboard took me to a court case titled Crime and the Act of Public Indecency in the online catalog. So what's interesting about the online catalog is that it also like gives them another name, right? So every court case has its own title. So this court case has been, aside from the tags, aside from the kind of cartons and its descriptors. So this one particularly was called Crime and the Act of Public Indecency in the online catalog. The case includes 2 Armenian men and 1 woman of unknown religious affiliation who were arrested in an alley. The case includes an eyewitness statement claiming that he witnessed, what he witnessed was not in accordance with Islam, nor with any creed and tradition of human assembly. And I'm quoting from the actual document. The ruling of the court, which includes a series of convictions and pardons, raises fruitful questions for us about the role of religious sensibilities and their relation to shame and decency, particularly in settings that were considered public. Documents are not merely tagged and titled using this method, however. Often the archivist enters keywords for court cases not according to the laws from the time of the creation of legal documents, but according to their own contemporary sense of legality and criminality. The same document that I just talked about, for instance, is tagged with the following terms: Christians, investigations, rape, infidelity, and harassment. While the title of the case echoes the vocabulary of the court documents, these tags demonstrate a rather different strategy of cataloging. Here, the cataloger has created alliances between crimes that are otherwise absent from the legal grammar of the 1910s. For instance, the cataloger has translated crimes of public indecency to harassment laws. Adding rape to the tags, and as such recasts the incidents with a completely different narrative. I suggest that we can use this slippage of language critically, interrogating the gap between harassment and public indecency. When did public indecency get to be reframed as harassment? And what does that tell us about broader shifts in law? Why would the cataloger deem this incident harassment also? Could this reading be related to the contingency of living in contemporary Tehran, where women find themselves being drawn into public spaces, on the one hand for necessities of life, while on the other hand enjoying very little safety in those spaces? Most significantly, what legal and moral life worlds do harassment and public indecency belong to? And what does this shift in terminology tell us about the shifting legal consciousness? So to give another example, in 1931, the case of Yadullah was brought to the Court of Misdemeanors on the charge of committing sodomy, lavot, forcefully with the 11-year-old Gholam Hossein. The Ministry of Justice that was responsible for the initial record keeping of the case referred to the file as a case of unchastity, BFAT, which mirrors the language of the Penal Code of the 30s. Curiously, however, the National Archives cataloger has labeled the file as prostitution. So we have rape on the one hand, and then or forced sex on the one hand, sodomy on the other hand, and then prostitution, which seems quite random, right? To add more layers to the multiple legal grammars present in this case, in the physical document of the court, the defendant, the 30-year-old man, is prosecuted not for rape, but for sodomy. These 3 different terms, rape, sodomy, and unchastity, tell us something about the conflation of rape with other forms of illicit sex that are not defined based on the question of consent. I suggest that these constructed affiliations and affinities allow us to interrogate our own contemporary conception of rape, unchastity, prostitution, and sodomy. What moral world does each conceptual lexicon open up, and what different forms of legal foreclosures do they make possible? I further want to draw attention to a mode of cataloging that at once entails a non-juridical but still legal moral adjudication. Legal consciousness is not simply bound by the space of the courts, but rather continuously spills out of the courtroom and into the consciousness of lay people, including the contemporary cataloger. In these cases, the vocabulary that I will discuss briefly, the vocabulary that the cataloger employs to label the court case implicitly contains a legal judgment, ingraining defendants and sometimes mistaking the historical claimants as criminals. So it's not just that people translate their own legal consciousness and sort of in the archiving process, but also they adjudicate, right? Archives do adjudicate. Let me elaborate through another example. Searching the keyword prostitution, the online catalog led me to the case of Mr. Mojaver Bani Sad. In November, this is a much later case. In November 1978, Mojaver pleaded that Ali Firuz Taj had seduced his former 23-year-old wife, Nusrat Deylami Hamdani, who ran away with Ali to another city, abandoning the claimant and their 5 kids behind. Mojaver, the husband or the ex-husband, presented the photo of Nusrat and Ali, the 2 lovers, as proof of their illegitimate namashru relationship. At the outset, this seems to be a case of fornication rather than prostitution. The only in vivo reference to prostitution in the court documents, including the judge's decision, the investigator's statement, as well as interrogation minutes, can be found in Ali Taj's statement, who is the man who the ex-wife ran away with, where he accuses his own lover of being a prostitute and her husband of being a procurer. Most probably, there's not enough sort of documents to understand details, to understand exactly why he did what he did, or why he sort of called his own lover a prostitute. But most probably, he was hoping to exonerate himself from the crime by accusing the other defendants. They are really just calling each other names at this point. So Ali accused his own female lover to be a prostitute and her husband as a procurer, probably to get out of just a legal hurdle. But what's interesting is that the court investigator eventually decided on an order of non-suit based on lack of any evidence, as well as prior dismissal of the case in another court branch. This means that the ex-husband, I know it's very nitty-gritty, but I'll make a bigger point about this. This means that the ex-husband had tried to convict his ex-wife previously in another court to no avail, and then he took it to another court. And this is something that is not possible anymore, but it was possible then, because courts have been centralized, much more centralized now. So yet, because the cataloger tagged the case with the court prostitution, Nusrat, the woman, is retroactively framed in the archives as a prostitute. For a historian of urban prostitution, which is me, the archive recast Nusrat as a subject of study. As such, the archive cataloger echoes the voice of the male defendant rather than the female defendant, subtly guiding the historian to her name, signifying prostitution. Labeling the archive then bears a legal decision made outside of the legal sphere of the courtroom. Thus, we see how a particular gendered legal consciousness conceals legal and historical nuance, imposing itself across the time space of courtroom. Put simply, archives adjudicate. So now I'm going to talk about the process of silencing. Legal archives further make and unmake their subjects. They articulate and disarticulate. They sign the ordinary person into the political language of the modern state. Available legal documents from this period, which is, my focus is really on the early 20th century, as I mentioned, post-constitutional revolution, including interrogation sessions, defendant statements, witness testimonies, and court reasonings, demonstrate how law created its subjects brought them into the legible space of the courtroom, while at once silencing particular kinds of statements and narrations of the self. Let me explain through another example. In 1924, a man named Yadullah was brought to court. Just one second. Yeah, I actually did talk about this one. This is the same Yadullah and Ghulam Hussein. According to this court report, Yadullah was accused of having tied Ghulam Hussein's hands, stripping him and raping him while threatening him with a knife. However, the case had no direct witness. The case was brought to the court by a public prosecutor, probably tipped off by the mother of the victim, who persistently followed the court decisions and eventually filed an appeal. So what we see in the court case is this mother continuously appealing, continuously sort of bringing the court for the case forward to the Court of Appeal, to the Supreme Court. She's very relentless. In the archives, you can see that. The penal code of the time required private claimants for crimes such as rape or illicit sex, unless they were committed in public. The Council of Judges, so this incident happened in a meadow. The Council of Judges did not consider the meadow where the crime had taken place to be a public venue. As such, they deemed the crime private. As a result, there was a need for a private claimant for the case to have legal standing. Being underaged and fatherless, Ghulam Hussein did not have a rightful guardian in the eyes of the law. Although the mother was the guardian, he didn't have a father. His mother, who was following the case in search of justice for his son, for the harm done to her son, was not considered Ghulam Hussein's lawful guardian, since the law only accounted for male guardianship. As such, the courtroom concealed the harm done to Ghulam Hussein, and with it erased the possibility of addressing that harm through the state apparatus. In the 1920s, the law only acknowledged assault insofar as the victim was defined within the bounds of the state's patriarchal definition of kinship within the nuclear family construct. Harm towards individuals outside of these patriarchal definitions was rendered invisible. The mother's claim was further disarticulated due to the specific grammar of legal claims and legal subjects. This case demonstrates how the immediate space of the courtroom, so we sort of moved from, tagging, online tagging, the archivist, and now like we're right in the courtroom. And this case demonstrates how the immediate space of the courtroom itself suppresses the articulation of certain affective bonds and familial structures, such as guardianship, that reside in a space beyond that of positive punitive law. Court archives can also tell us something about how ordinary people translate and transplant their lives into and through the law. In 1932, Aqdas-ud-Dawla, the lady of a household, brought her servant to court for having taken a lover, claiming that this incident, indecent behavior, had damaged the reputation and honor of her household. A side note here is that the servant was providing child support for Aqdas-ud-Dawla. And since she was illiterate, she actually made Aqdas's children write love letters to her lover using very erotic language. And really, this was Aqdas's beef with the servant, but she was thinking what language would be this legible in front of the law. And so she used the language of damage to my household. She drew on her own conception of kinship, which differed drastically. Let me go back. Aqdas emphasized that since the servant, now 24 years old, grew up in their household from the age of 4, she should be counted as a member of their family. And as such, her chastity equaled the chastity of the family. She drew on her own conception of kinship, which differed drastically from the official legal conception of family based on blood. Although beyond the scope of this talk, it is worth mentioning that her conception of kinship ties based on factors other than blood is rooted in a servitude culture and practice that is now obsolete in Iran. But it was common for servants to grow up in the households that they served, and as such, they were some quasi kinship ties between the servant class and the ruling class. Let's call them ruling class. So Aghdas's claim, however, had no legal standing, since the law did not consider the lady of the house as the servant's legal guardian. Aghdas's lawyer then had to come up with another claim, because she clearly comes from upper middle class family. She has money to spend, so she has a lawyer in 1924, which in itself says that she comes from a pretty powerful family. The lawyer decided to accuse the servant and the lover of stealing silver chandeliers from the house, which is, I think, an ironic twist. If the servant is like kin, then how could she have stolen from her own household? This discrepancy is beside the point, however. My intention is not to discuss the process of adjudication here, really, but rather to show how law-conscious subjects misperform sometimes their subjectivity in the courtroom. And in doing so, they provide the historian with an opportunity, in this case, to rethink the notion of kinship. This period, as I will discuss momentarily, is in fact actually a period of misperformances in the court's room, as the legal system was also transforming radically, and as such, lawyers, defendants, plaintiffs, all in a way fail to perform their law appropriately. So in reading these legal archives, we should ask ourselves which experiences, subjects, and relations are eroded, and which ones are made visible in this legal life world. These two cases I propose demonstrate how the courtroom makes certain claims unstateable and certain kinship ties incomprehensible before the law, while nonetheless creating the possibility for both defendants and claimants to narrate themselves and their actions through the language of law. The disarticulation of certain kinship ties in the courtroom points towards a much deeper and broader historical transformation in the early 20th century following the Constitutional Revolution, which in fact led to this very disarticulation. So I'll try to provide a briefish kind of history to the legal transformations that were happening in Iran and their significance. Now, let me switch gears here and address this historical transformation that significantly was concomitant to the archival transformation that I mentioned earlier in the beginning of the talk. Early 20th century Iran witnesses the rise of the modern nation state, one of the pillars of which is modern positive law. The 1910 to the 1930s are significant years of legal experimentation in the history of Iran. The codification of penal and civil law, together with the dismantling of the dual Shari or Fi court system and proceduralization and centralization of law, were a part of the broader process of legal reform brought by the post-constitution state. Now, it was in this period that the category of moral crime appeared first in the 1916 version of the Penal Code. Moral crimes referred to acts of public indecency, sex with minors, rapes, attempts to persuade, deceive, incite, or encourage the youth towards dishonorable and lustful acts using moral corruption, and finally, prostitution. In the 1925 version of the Penal Code, zina and sodomy, both of which are actually had crimes under the Shar courts, were added to the category of moral crimes under crimes against honor and transgression of chastity. This transplantation of Islamic Sharia language onto the Penal Code was part of a broader effort to fold Shar into the workings of modern law. And the point I'm trying to make, as you will see, is not about the Shar really, but it's about a very deep shift in the mechanism of the law in and of itself. In 1931, a new amendment to the law annulled Shari penal trials altogether. Significantly, in this iteration, the term zina, which is illicit sex, was exchanged with fornication, which has no religious connotation. And sodomy was moved under articles which dealt with non-consensual sex. So now we see these sort of new concepts being emerged in the law, such as consent. As such, not only the language of penal law was emptied from the language of shar, but also trials effectively cut off shari courts from the field of penal law. The positive law of the modern state is commonly described as imposing its sovereignty over the moral universe of shar and its form of authority. Legal reform across the Muslim world in the 19th and early 20th century has been casted as an operation that refitted, suffocated, and minimized the space of shar, but also the space of moral law. And that is the point that's important here. A process that is referred to as secularization. And there's a robust scholarship behind it. The process can be seen clearly in the final amendment of the Penal Code. Passed in 1933, this final iteration renamed morality laws as crimes against unchastity, public morality, and family values. Without getting into the debates around the shifting relation between Sharia and the state, I want to emphasize a significant point that this scholarship highlights. As it echoes a prominent also theme in legal political theory. Hart and Walter Benjamin have famously talked about this, which is that state law, particularly punitive positive law, is devoid of morality or ethics. At the same time that the parliament folded Shari crimes such as zina and sodomy into the penal code, law and morality got to be seen as further detached based on the positivist legal aspirations of the reformers. We can even see this, I'm gonna skip, actually I'll just read this from the legal collection periodical called Majmu'e Huquqi in 1928, where a commentator wrote, and I quote, "The penal code is only to maintain security. The legal system does not have its eye on the individual moral good or moral responsibilities. People's actions will not be penalized simply because they are not moral. Personal morality is the matter of inner police. Police batini." Shar or not shar, legal archives demonstrate this suppression of non-penal consciousness in the space of the courtroom. So now let me go through two court cases very quickly. I'll try to go off script here. So I want to talk about, I'll just actually talk about maybe one of them, not both of them. There's one case, the final case I want to close this presentation with is that of Hassan, a 13-year-old boy who worked in a bakery and was arrested for sodomy in 1922. This case includes many back and forths between Hassan and the judge around the age of Hassan and if he should be seen as an adult or not. Since this is a time when the age of consent for sex was also not yet set, the jury had to decide whether to frame this case as sodomy or as sex with minors. The implication of these two readings of the event are vastly different, since one sees Hassan as a criminal and the other as victim. The judge eventually decided that Hassan must be treated as an adult as he worked and provided for his mother. So based on his social role, right? Not based on his age, really. He was seen as an adult. The judge but what's interesting is that the judge first convicted Hassan, but then pardoned him in the Court of Appeal on the grounds that he had an elderly, ill mother whom would not have been able to survive without Hassan. Since he had no previous records, the judge gave him probationary release for 5 years. So if he did not repeat the crime or was not caught doing so, within 5 years, his records would be clean. Here we have yet another situation where the male subject of law claims, propriety through affirming family responsibilities, right? This ruling, I think, is based on a very different conception of justice from the punitive notion of justice. One may call this restorative justice or transformative, that is based on a relational understanding of subjectivity and not a personal. So morality is not just personal. Because he's taking care of someone else, he's going to be looked at as like an relational subject. So rather, Hassan's subject position is defined in relation to other people, particularly his dependent. And I think this case shows the immense potential of legal sources for historiography from below. It is through these cases that we can begin to trace non-punitive traditions and practices of justice in modern Iran. Similarly, gaps between archival and legal taxonomies and misperformances in the court are all opportunities to further interrogate into the historical rupture and continuities that were brought by the modern nation state. 1 minute. Archives make and unmake such subjects, as I mentioned. In the past decade or so, historians have been trying to write against early 20th century statist historiographies of modern Iran. Legal archives are fantastic sources for such approaches. Law as the cornerstone of the modern state is a particularly generative site from which to interrogate how subjects are signed into the state, and also how traces of non-legal, non-modern states, forms of living continue to reside within the space of law. I'm going to stop here. I had some more thoughts, but I'll just stop it here. Thank you. Sorry.
Well,
I took too long.
Thank you, Dr. Gahan, for your fascinating presentation and taking us into a tour of both online and physical archives, categorizations, and all the problems that you describe, and the use of it for historians to think and rethink. Now we have you all have the opportunity of asking questions. Anyone, if you have questions, please raise your hand, and we will go through questions one at a time. Yes, Dr. Asgharieh.
Thank you, Dr. Tabakoli. Very, very interesting subject and presentation. Thank you very much. Just a brief question, Jairan. In your search, did you come across the file belonging to the notorious child molester, be that Asghar Qatil, Asghar the murderer, if you like? Did you come across that file?
This is a serial
killer.
murderer.
Yeah. No, not
going
that one.
after kids.
No,
children.
I actually didn't, and I don't know
but
why.
This is a very important case.
Which is also interesting. I mean, it also tells you that legal archives don't, tell you everything, and they're not. No, but I did come across the kind of the Shahrano, the few criminal sort of let's say personalities in Shahrano. I think one of them was also called something else, Qatil, but also not in the legal archives, actually in a different kind of archive. So interestingly enough, either those have not been cataloged yet, or because Asghar Qatil had such a public presence
in the media. In the newspapers of the time, you will see a lot of reports on it. And also, since I used to live closer to the southern part of Tehran, out bounds of Tehran, always our family instilled this fear of Asghar Qatil. Don't go to this place, don't go to that place, because Asghar Qatil will get you and kill you.
Yeah. No,
I do other
remember
things,
that.
of course. Yeah. Dr. Asgharieh, do you want to add anything more?
No, thank you. No, it was very interesting. It is very, very novel subject, and I must congratulate you for having chosen it and having a presentation. Thank you.
Thank you. Any other questions? Yes, Shadow C. Please.
Yes, thank you very much for the presentation. Very interesting subject. Having grown up in Iran many years ago, it comes to my mind, you talked about the idea of rape of the minor. How did the courts or Iranian thoughts dealt with how often servants, young servants in the household, were raped by the male members of the household? And sometimes there was some kind of sighe, marriage arranged in case there were pregnancies. Has there been anything in the files indicating any reports, or were there something that was never talked about?
I mean, I think that's a fantastic question, and it actually allows me to also mention that there is immense power dynamics involved in these archival sources court cases. So the case that I just went through around the issue with the servant and the madam of the house was actually brought to court by the madam of the house because she had money, she had a lawyer, right? So servants, my initial response, I haven't found any, and I would be very surprised if I did find any. I think oral history, for example, would be a much better sort of source to look into or to find instances of that, because this is the official, this, in a way, legal archives do represent the status quo. I think what I was trying, and the status quo were the male, patriarchs of these families that were richer, had more resources. So it would be highly, I would think that it would be very hard to find those instances. I have come across cases of sex with minors. A lot of times, actually, these include women who eloped or ran away with their lovers. And then the father came sort of took the boy and the girl to basically the courtroom. So you do see, and then there is discussion around, is this person a minor? How do we decide, especially in the absence of a set age? I think those are interesting in terms of giving us some insight into how did people think about adulthood, but they don't really give us an insight into domestic violence. Domestic violence, I think, in general, has always been underreported, but there was no record of domestic violence.
And
not even also women, right? The wives themselves, even today.
It also raises a question in my mind. How do you see rape of the minor when by law you're allowed to marry a 9-year-old in the culture? So how did they see that? Did they see that? I mean, did the courts ever looked at the fact that, a 9-year-old being married off, would that not be considered rape?
I think yes, at some point it starts to tip over, but in the period that I'm looking at, which is 1910 to 1930, that's the focus. Rape, the language of rape, is actually fascinating. The language of rape has to be tied to physical harm. So it's not about consent. Consent as a legal concept did not exist in pre-modern forms of law, right? Consent as a concept. So there was illicit sex, there was bad sex. There's always been an idea of bad sex, but it didn't. The only way in which, and the only way in which the 9-year-old or whoever could bring a case of sort of rape to the courts was if they were physically harmed. And in that case, it would be actually trialed as a physical harm and not as a sexual harm, right? Or a sexual assault. I think I really love your question. I think I've never published, but I've presented on the sort of different conceptions of illicit sex and how, language give us something, and then there's a lot actually written about does shar recognize unconsensual sex? It doesn't, but it does recognize harmful sex. But the way harm is defined is based on physical harm, not emotional harm, and not mental harm for sure.
Did these cases ever go actually to court? Or did they just make a judgment based on just catching them? And
well, you mean the women? So the one that I talked about earlier, the case of Ghulam Hussein and her mother. So that was a case of rape, and I think she could bring it to the court so easily because he was actually a man and not married, and this was, not within the institution of marriage. It is still very difficult to actually present a case like that. So you see, or I've seen other instances of rape being brought to the courts or sexual assault being brought to the courts. And this is also because we have the friction and codification of law. So when the law gets codified, they take an exact part of the Mann Act from the US, which was passed in 1910, and it was actually against mobility of women. It's called White Slavery Act or Mann Act. So they take that, which is mostly around persuasion, insight. So it's about tricking women into sex, right? So that language is sort of brought from the American legal system to the Iranian legal system, almost word by word, and it does give some language to people who want to take these relationships to court. But what's interesting is that the one who has been harmed never brings them to court. It's always their guardians, because they are the ones who decide that this person has been deceived, right? So the person who's in the relationship would never, they're the ones who are quote unquote brainwashed into the relationship. So it's a fascinating, I think, sort of topic to get into. But yeah.
Does this come from the idea that women were owned or women were belonged to and they were namus? Or was it because, or did they see women as individuals?
No, they didn't see women as individuals, and that is why they couldn't become guardians, right? They couldn't become guardians. If they were married, it was a done deal, right? It's very, very difficult to bring a course of rape. And this, by the way, like continued, I think, until maybe 10 years ago, 15 years ago in Iran, right? So yeah, they did not. Women couldn't be guardians. You see, like, very clearly in that example where the mother is unable to file a complaint because she's a woman.
Thank you so much.
Thank
Truly
you.
enjoyed your
Really
presentation.
interesting questions. I hope I answered them properly.
Very well, thank you.
Thank you. We have one last question. Shokufe, please.
Hi, Dr. Gahan. Thank you. It was wonderful. And what you just said in the answering to the last question about physical harm, that rape only could be as a physical harm. And I was thinking, so actually physical harm, that comes, it made me to think, you correct me, that if sexual rape, sexual harm is a physical harm, even if it doesn't create an injury. But the physical harm is a male concept here. I mean, it has, from the male point of view, it has to be some kind of patriarchal twist on this, not seeing forced penetration, just the penetration itself as a physical. It is to the physics of the body of the woman. And that in itself had psychological harm. All of these are connected together. But when you take that and put the physical only if it is you are damaged. And there is something in that damagedness, as if it is more, it came to me, is that itself is the male perspective on what harm, physical harm is.
I really love that. And, you know, we just read together that article of Shahla Talebi's, the new article about rape, and what is the difference between physical harm? What is the difference between, you know, sexual assault and assault? And it seems, I love that comment.
Yeah, that's, it made me think on that. And also what you were saying about the role of the tagging, for example, creating a representation of the, I mean, the whole quality, what it does changes everything. So that again brought this to me, that the sensitiveness of the role of a historian, archivist, and you go and look through it, rather than taking those codes as a signifier, but actually deconstructing them. And because then you can perpetuate, if you're just doing, that's perpetuating the same thing, and that paradigm of thinking and paradigm, the old paradigm, you can perpetuate it to the future, but that makes your job very sensitive and very important. Thank you.
Thank you for a very good question. Interesting question. Thanks.
Thank you.
Professor Azad?
Oh, thank you so much. Sorry, I had asked my question in
I just saw it,
but I realized that maybe it wasn't visible. Yeah, so I really liked what you said. That really stuck with me. Archives adjudicate. So I wondered if you could speak a little bit more about that, and maybe give an example of how, I think it's so powerful what you say. You know, an archive we often think of as an objective sort of bureaucratic process with no sort of political implication, but I think you've shown, but that's what you were alluding to, that that's actually not the case. Could you give us a little bit? This is a very interesting topic.
Yeah, sure. So the example that I drew on, the particular one that I drew on, was when the archivist, and I know I go through these legal court cases, so hard to present them in a way that people can take them in. Because yeah, it's so the example that I particularly drew on was when let me just, so there was a case where it was tagged as prostitution, and it took me, so when I searched prostitution, it came up, right? And then those records that I showed you also, in the descriptor of the court case, it says prostitution, fashion. So I kept looking for who's the prostitute? And then the case has three people, two defendants and one claimant. One of the defendants is the woman, and prostitution was understood as a gendered, only women's sort of profession at that point. So I look at this and I see Nosrat's name there. So Nosrat becomes the prostitute in my archive search. So someone, so this is what I mean by adjudicate. Whereas the court very clearly is actually about illicit crime. So it's not even about prostitution. And also one of the defendants calls the other one out for prostitution, and the judge immediately dismisses this. So I like this case particularly because you can see how the judge is saying this is not a prostitution case. This is even not a fornication case, right? Because these two people aren't married anymore. So there's no case for the judge, and this is not a Shari'i court, so it doesn't matter. But then the archivist has taken the liberty to tag this as prostitution. So the archivist is actually kind of striking that affinity between prostitute and Nosrat, and making me bring Nosrat into my book, let's say, about prostitution. So you see what I'm saying? So she's becoming, she was exonerated then, but she's like finding her way back to the field of prostitution through my work because of the archival, because the archivist just saw the prostitution and she said, oh yeah, this case is about prostitution somehow.
So
But it
the
wasn't.
filing, so yeah, it's brilliant. So the filing or the clerk or whoever did this and called it prostitution, do you think that's an error or do you think it's intentional? If it's intentional, why call it prostitution? Is it because I, as the filer, as the archivist, I'm interested in any case in which someone might have been accused of prostitution, irrespective of the outcome? Like, what is the logic behind this archival note, do you think? And are there more like that? More cases?
There are more like that. And I took the ones that were very, that were actually about sex crimes, but a lot of times you see people calling each other names and the archivist tagging it. So that happens a lot. A lot of times you see, like I have a case where a 12-year-old, for example, breaks into the house of some private house and they report him as and then it somehow gets tagged as prostitution. I think I love your question, and I think that's what I'm trying to work through in this presentation, which is what is that consciousness, right? It's not about right and wrong necessarily, but it's more about what is that consciousness that lumps all of this together. It's like anything sex related, I'm gonna do prostitution, or anybody calls anyone, right? So it is a unintended, I think, consequence of clustering these things. And it's not that it's necessarily right or wrong, but it does have implications in the sense that Nosrat gets dragged into my book about prostitution. Like just think about that. Like she again appears, although like 80 years ago she got exonerated. So I think there's there is a very vague, very broad understanding of sex crimes when the archivist is tagging them. And there's no kind of, or also think about the other one, which was harassment versus prostitution, or harassment versus public indecency, right? So I think it does tell us about how archivists, maybe consciously, maybe unconsciously, think about sex crimes, right? It's not just that it was tagged by prostitution, but it was also in the bucket of sex crimes, right? So you find these random. That was the riddle. Why are these random, cases, none of which are about prostitution, here in the prostitution file? And I think there is an affinity that is drawn between this kind of crime and rape. Whereas these are very different kinds of crimes, right? And the point I make in the longer version of this work is that moral crime, these are all crimes that are around morality. So there is something that brings them together. Morality and sexuality have a very close affinity. So there's so much work that one can do with this sort of maybe mishap, right? Or misperformance. There is a logic behind it.
Thank you, Jairan. Next question from Gunha Kim, please.
Hi, thank you so much for your brilliant presentation. So I wanted to learn a little bit more about your idea on so-called social history of crime in Iran. So I suppose law has also been revised like during the decades you have observed. So I wonder whether you have observed any dynamic conversation between court and legislation, where those like court cases leading to more tighter, like newer legislation in Majlis, like if plaintiffs like make some clever like legal moves, like state will like try to mend those like holes, or like any conflicting like statements in like law. So I also wonder, like, do you observe like any general trend of like increasing criminalization of like social behaviors, or maybe opposite, like decriminalization?
Great question. I'll answer the first part of your question first and then the second part. So absolutely, yes, I do read all of these. The whole point is to read these sort of in line with historical shifts, legal shifts that were happening. Because this is, as I said, super interesting time for Iran. This is the time for legal experimentation. So everyone's experimenting. One of the interesting things, for example, that I tackle, there was no time to really get into it here, wanted to do a lot of different things, but is the dismantling of the Shar'i court and then folding, I call this process folding Shar. So we usually talk about, scholars of anthropology of Islam and secularization talk about the process of modernization of the state as one that sidelines Shari'i crimes to the private sphere of personal status law. So I'm not working with personal status here, I'm working with crim law, right? But in crim law, we actually see this clearly, that zina was a public crime, and then it gets sort of folded back into, so when the Orfi, and we had an Orfi court and a Shar'i court, they dismantle all of those, they make a sort of centralize the court procedures and everything. So what happens during this very period is that zina gets to be folded as, and talked about, and sodomy as well, as private sort of harms. So when I talk about that particular claimant's Ghulam Hussein's mother, right, who can't claim, in 20 years before, this crime would be seen public and a public defendant could take it to court. But then she can't. So then answer the second part of your question. So yes, shortly, yes, social history. And I love this. I love legal archives because they actually show us how claimants and defendants and lawyers and lay people as well as legal professionals try to navigate rules, the law in many ways. And you see how I don't want to go on forever, but you really open the can of worms here, because they really the ways in which people, and my whole sort of idea is that the way in which people translate their moral sensibilities into the legal language of law shows us the gap between a very different sort of understanding of justice and the one that is getting established and consolidated. So I can't say I see further second part of your question. I can't see a linearly progressive sort of line. Also, I think the kind of work that I've done is not quantitative, very difficult to make a judgment like that. They do spring up more after the 1930s and 40s, but I think the reason why you see more criminalized cases of sexuality is not like Gail Rubini, it's actually just that they started to collect more of them and people started to probably, so it's a matter of actually archival keeping of them. I don't know if they were really less reported or more reported. I would think they were more reported. I would assume that would happen, but my sources are not good sources for that.
We have a follow-up question on Ghulam Hussein's mother from Zainab Marvi. Zainab, please.
Hi, thank you very much for this really amazing presentation. So I wrote it in the comments that the last case that you might describe was dismissed on the basis of his familiar relation to his mom. And I was wondering that if you came across cases that were prosecuted or not prosecuted based on economic or political background, like I'm just wondering if the cases were registered against people who mainly came from a low-income background or were dismissed on the basis of their political influence or something like that.
Oh, I see. Not really. I haven't seen anything. You can kind of tell, a lot of times you can tell that the person had a lawyer. So I'm not looking at those cases here in particular, but sometimes you see really well drafted, right, appeals. And it's like clearly whoever could afford that I think it's Amin something. Amin. He was one of the first lawyers, and he's non-existent in the public discourse and media. So if you look at media resources, you're not gonna find this Amin guy who's apparently, I think, a very powerful lawyer in Tehran, and he takes a lot of these kinds of court cases. And one of maybe actually answering tying your question back to the previous person's question, a lot of times what we see is initially when the Shari and Orfi court cases have been rearranged but not completely dismantled, this Amin guy really ruthlessly manages to take a case of, I think, fornication or something from the Orfi court to the Shari court so that it's zina, and zina, as we all know, is extremely hard to prove. So he pardons, so he sort of uses this sort of dual system, or the waning dual system, really, to pardon his what do you call it? His claimant, and he is his defendant, and he successfully does so. So you see a lot of these confusions about does this case has to go to the Shari court or the Orfi court, and people totally manipulate that. But I think also the ones who manipulate that are the ones who have a lot of resources, right? So in the sense of servant, say ruler, or the lower class being brought to court more than others, I did talk about the one case that was about the servant and the madam, right? But not necessarily. You see a lot of, like, I have a very interesting case of a lot of men whose partners or previous partners betrayed them, or like had new lovers, or went to brothels to work. So a lot of, I have ex-temporary mut'a husbands bringing their now prostitute wives to the court for saying, you left the marriage early, the marriage wasn't ended, you started prostitution. And you kind of see that prostitution is not really the problem, zina is the problem, right? So and these guys, one of them was his name, when they also described what they do in these, what is their profession or career in the archives, the guy was Geda, which is like beggar. So a beggar brought his previous wife, and he had like 3 mut'a wives at a time. Good economic times. I have no idea how this happened, but it's interesting that even a beggar would bring his ex-wife to the court, right? So it's interesting. What's very interesting to me is to acknowledge how combative people were, and how aware actually they were of the possibility of battling their cases in the court. And that might be a reason, be tied to the local courts before the reason for this might be tied to the existence of Shari courts that were super local, very small, and people probably just took their neighborhood disputes all the time to these court cases, to these courts. Now it's very hard to imagine, right, someone who has no financial ability to go to the court, because it's all centralized, and it's so difficult to have access to the legal sort of system. The legal system seems to have been much more accessible to people. That's very interesting. I haven't thought about it, but now that you're saying, I'm like thinking back, it seems to actually have become more increasingly unavailable to lay people.
Very interesting. This final case. Dr. Gahan, thank you for your brilliant presentation.
Thank you.
And we are all, but me particularly, looking forward to the publication of your Red Light Tehran, Prostitution, Intimacy, and the Rule of the Sovereign.
Thank you. Thank you all for coming and for listening to me for an hour and a half.
Thank you.
Okay.
Thank you all for joining us. We'll see you soon.